H-1B lottery results are out. What selected applicants must do now. The moment thousands of people have been waiting for all year is finally here. The H-1B lottery results for fiscal year 2027 are out. And if you were selected, what happens in the next few weeks could shape your entire future in the United States. But let me say something right at the very start. Something more important than anything else in this entire video. Selected does not mean approved. It does not mean you have the visa. It does not mean you are safe. And it absolutely does not mean the hard part is over. What it means is this: your registration was chosen and now your employer has the legal right to file the full H-1B petition on your behalf. That is where the real process begins, and I want you to really sit with that for a second, because every year, every single year, thousands of people get that selected notification, breathe a sigh of relief, tell their family, celebrate, and then slow down. They assume the rest is just paperwork. They think someone else is handling it, and that is exactly where things start to go wrong. USCIS stated that selection notices for the FY 2027 H-1B cap would be issued by March 31st, 2026. Those notices went directly into employer and attorney accounts through the My USCIS portal, not to you, not to your personal email, to the people who filed the registration on your behalf. So if you are still waiting and wondering, stop refreshing random websites. Stop waiting for some email from USCIS to magically appear in your inbox. That email is not coming. Instead, contact the people who actually control the filing: your employer, your HR team, or your immigration attorney. Pick up the phone today. That is where your answer is. Now, if your registration shows selected, here's exactly what must happen next, and I want you to pay close attention to every single step. Your employer must prepare and file the full H-1B cap petition. This is not one simple form. This is a complete legal package, and it must be done correctly. The package typically includes the petition itself, employer documentation proving the legitimacy of the job offer, evidence of your qualifications, your educational credentials, and something called a labor condition application, the LCA, which must be certified by the U.S. Department of Labor before the petition can even be submitted to USCIS. That LCA step alone takes time. The employer must post a public notice at your worksite for 10 business days. The job title, location, wage, and occupational classification all need to be accurate and consistent. Any mismatch between the LCA and the petition is an immediate red flag. So as soon as you confirm your selection, start gathering everything your attorney or HR team will need from you: your passport, your degree and transcripts, your resume, your current immigration documents, any prior approval notices, your I-94 record, your work authorization history, anything they ask for. Do not delay this, because one of the biggest mistakes selected applicants make every single year is assuming they have plenty of time. The filing window may look generous on paper, but attorneys are preparing hundreds of cases at once. Employers are juggling multiple employees, documents go missing, forms need revisions, and before you know it, weeks are gone. The people who move immediately give themselves the best chance. The people who wait are the people who end up in trouble. Now, I want to address something that trips people up emotionally every year. The word selected feels like victory. It feels like you made it, and it is genuinely exciting news. I am not minimizing that, but USCIS approval after selection is not guaranteed. Your petition can still receive a request for evidence, what immigration attorneys call an RFE. That is a formal notice from USCIS saying they need more information or stronger documentation before they can make a final decision on your case. Receiving an RFE is not a denial. It is a second chance to prove your case, but it adds weeks to your timeline. It requires a careful, thorough response, and if you miss the response deadline, or if the response is incomplete, your petition can be denied on the existing record. RFEs most commonly happen when the job description is too broad or vague, the position does not clearly require a specific degree in a specific field, the employer's documentation is incomplete, or the worker will be placed at a third-party client worksite rather than the employer's own location. That last point matters more than many people realize. If you are working at a consulting company, or if your role will place you at a client site rather than directly at your employer's office, your petition usually requires extra documentation. That means contracts, statements of work, organizational evidence, and proof that your employer, not the client, is the one directing and controlling your day-to-day work. If that documentation is weak or missing, your petition becomes much more vulnerable to scrutiny. The way to reduce your RFE risk is simple. File a strong petition from day one, strong job duty descriptions, clear degree alignment, solid employer documentation, and an experienced immigration attorney reviewing every element before submission. Now let me talk about premium processing, because this question comes up constantly, and a lot of people are unsure whether it is worth the cost. USCIS offers a premium processing service for H-1B petitions where the agency commits to taking action on the case within 15 calendar days. That action could be an approval, a denial, or an RFE, but at minimum, you will know where things stand quickly. Under standard processing, petitions can take months. And for someone whose work authorization is about to expire or whose job start date is time-sensitive, waiting months for a decision is genuinely stressful. Premium processing does not improve your chances of getting approved. The petition still needs to stand on its own merits, but it dramatically reduces the uncertainty and gives you a much faster answer. For most people in 2026, if the cost is manageable for your employer, and in many cases employers do pay this fee, premium processing is worth serious consideration. Now let us talk about the people whose status is still showing submitted. If that is your situation right now, take a breath. Submitted does not mean denied. It does not mean rejected. It means your registration was not selected in this first round, but it remains in the system. USCIS may conduct additional selection rounds later in the year if not enough petitions are filed from the initial selected pool to meet the annual cap. If that happens, registrations currently showing submitted are automatically considered. You do not need to do anything extra to remain in that pool. A second round, if it happens, would likely not occur until mid to late summer. So stay in close contact with your employer, keep your account active, and watch for USCIS announcements throughout June, July, and August. But, and this is critical, if your current work authorization has an expiration date coming up before then, you cannot afford to sit and wait. If your OPT ends before summer or your STEM OPT extension is running out, you need to start thinking about alternatives right now, not later. Now, what are those alternatives? Let me go through them. Some universities, nonprofit research organizations, and institutions of higher education are cap exempt. That means they can file H-1B petitions year-round without any lottery. If your field has any connection to academic research or nonprofit work, this pathway deserves serious attention. The O-1 visa is available to individuals who can demonstrate extraordinary ability in their field. That sounds intimidating, but many strong H-1B candidates actually qualify through publications, professional recognition, significant salary, media coverage, speaking engagements, or critical roles at distinguished organizations. If you have a strong professional record, ask an immigration attorney whether O-1 might be a viable path. The L-1 visa is an option for people being transferred within a multinational company. If your employer has international offices and you have worked there for at least a year, this could apply to you. TN status is specifically available to Canadian and Mexican citizens under trade agreements and is worth understanding thoroughly if either of those citizenships applies to you. And regardless of which option you explore, do not wait until your status is about to expire before having these conversations. That is how people end up forced out of the country, not because there was no option, but because they waited too long to pursue one. Now let us zoom out for a moment and look at the bigger picture of what is happening to this program right now, because the H-1B landscape in 2026 is more complex than it has been in years. USCIS has been applying stricter scrutiny to petitions across the board. The standards for what qualifies as a specialty occupation, meaning a job that genuinely requires a specific bachelor's degree in a specific field, are being examined more carefully by adjudicators. Positions with broad, vague job descriptions are being challenged more aggressively than they were a few years ago. This means that even if you are selected in the lottery, the quality of your petition matters more today than it ever has. A generic job description copied from a job board is not going to cut it in this environment. Your attorney needs to build a specific evidence-based argument for why your role is a true specialty occupation and why your degree qualifies you for it. This is not meant to scare you. It is meant to help you understand why preparation matters so much right now. The lottery is one hurdle, adjudication is another, and in 2026, both hurdles are very real. Now let me bring everything together with the timeline you need to have locked into your head. USCIS began releasing selection notifications on March 27th and was completing them by March 31st, 2026. The petition filing window opens April 1st and runs through June 30th, 2026. Selected employers have at least 90 days to file. If a second lottery is needed, it likely would not happen before mid to late summer. And the earliest an approved FY 2027 H-1B worker can begin employment is October 1st, 2026. Every date on that list matters. Every deadline is real, and missing any one of them can set you back by a full year. So here is where things stand right now, and here is what I want you to actually do when this video ends. If you were selected, act today. Contact your employer or attorney immediately. Confirm your petition preparation has started. Send your documents without being asked twice. Ask whether premium processing is being used and understand that the real work is just beginning. If your status says submitted, stay ready, stay reachable. Monitor USCIS updates through the summer, and in parallel, parallel, start exploring what your backup options look like, not as a backup plan you are resigned to, but as a smart contingency you are prepared for. If you were not selected, do not disappear, do not freeze. Talk to an immigration attorney soon about your current status timeline, your alternative pathways, and how to position yourself more strongly for the next cycle. The next registration period will come, and the people who prepare early are the ones who show up ready. The H-1B visa has built careers and changed lives for decades. It is still the primary pathway for skilled international workers to live and work legally in the United States in specialized fields. And despite how complex and uncertain the process has become, it is still very much achievable for people who take it seriously. But the era of passively hoping the lottery falls your way and then figuring out the rest later, that era is over. This process now rewards people who move early, prepare carefully, build strong cases, and work with professionals who know what they are doing. So if this process affects your life, your job, or your future in America, treat it with the seriousness it deserves. Move early, move carefully, and protect your case like it matters, because it does.